All right. Good morning, everybody.
Good
We
morning.
are just getting ready, and we've got Sarah all ready to go. So we're going to wait, and we'll start promptly in about 2 minutes. So go grab your coffees and go to the bathroom, go pet your dog, water your flowers, whatever you need to do. So we'll be ready to go here in a couple minutes. I was so excited to see blue sky last night. I was like,
Oh my gosh.
praise
It's a relief, isn't it?
praise the Lord. I saw blue sky and woke up and the sun was shining this morning. I was so happy.
I can't wait to mow my lawn.
Oh, I know. Yeah. We have Orioles, we have hummingbirds, we've got bluebirds. It was just so awesome this morning. They were just all going crazy and it was awesome.
Yes, it's going to be a beautiful weekend. I'm really excited.
I think we all deserve it. We all deserve a wonderful Memorial Day weekend because there have been times when it snowed, that's for sure. So
yeah, or just cold rain. I just remember a lot of cold, rainy Memorial Day weekends. So.
Yeah, exactly. All right, well, it is 10 a.m. So we want to get started. Our goal for all of these webinars that we're going to be doing is to have them be impactful, informative, fun, and short, because we know all of you guys are so busy and you might be a little webinared out as well. So we want to make sure that what we bring to you is very informative. So the flow of the meeting today is Sarah's going to take over after I do the introductions. We're so happy, Sarah, that you're joining us and you are our subject matter expert on this. We have learned so much from Miller Johnson throughout these past months that it's just been a great partnership for us. So Sarah's going to take over for me. She has the top 10 questions that everyone submitted, and we really appreciate that you guys have done that for us. It helped us out on the direction that we wanted to go. And then at the end, I'm going to talk a little bit about our upcoming seminars that we're going to do. And probably most importantly is we're going to have a little giveaway. We're going to do a summer 6-pack giveaway where we're having Nulty coolers made up. And whoever is the winner will get to choose their 6-pack of choice and a little gift pack that we're going to get to you. And we'll deliver this once we get through this pandemic, if we ever get through it. So Sarah, I'm going to turn it over to you. Oh, also, I forgot to say that Carrie will be watching the Q&A down on the bottom. So everybody knows Carrie Nicholson, and she's going to be watching the Q&A down on the bottom to see if those questions are being answered. And if they are not, we're going to save some time at the end that Sarah will be able to hopefully get to those at the end of the presentation. And if not, we can follow up after the seminar. So thanks so much for joining us for our first virtual seminar. This is so new to all of us, and we're excited that you guys joined us this morning. So Sarah, take it away.
Thanks, and thanks so much, Susan. For those who know me and haven't seen me in a little bit, you can all see my hair is a little bit longer, but I'm still here. We've been sorting through COVID-19 questions for the past, I don't know, 2 months or so, and helping lots and lots of clients and businesses track the 92 and counting executive orders issued by our governor, not to mention, as you guys all know, a number of local county health department orders, continuing changing guidance from the CDC and from OSHA, et cetera. So I suggested to Susan and Carrie that we really hear from all of you about what questions you have now. And so we did that. And so these are the top questions that I'm going to cover in the next half an hour or so. I want to show you guys the list now so that you can see what I am going to talk about, as you might want to be asking follow-up questions while I'm talking. So each one of these I'm going to answer between now and about 10:30. So let's jump in. The first one is, does my business have to perform a daily health screening? True to form, the answer to this question changed this week when Governor Whitmer issued Executive Order 91. Executive Order 91 now requires all businesses with any in-person operations to include a daily entry health screening that has to include at a minimum questions about whether that individual has COVID-19, has symptoms of it, or whether they've been exposed to people with positive COVID-19. Importantly, and this part is buried a bit in the executive order, so not everyone may have seen it, but also we have to maintain a record of that screening. Now, we're getting lots and lots of questions as to what that means that we have to maintain a record. And the reason for that is many businesses, including larger businesses, it's unworkable to have some sort of paper questionnaire exchanged every time employees come into that workplace. So they're using some other method like a phone app or things like that. We've looked carefully at the language in the executive order, and we think that employers have a very good faith argument that they've satisfied that record requirement if they record that they've done the questionnaire for all employees, but that they don't necessarily have to have a record of each individual's responses to that. So for example, if you can know what questions got asked on each particular day, and you know who was excluded because they answered yes to any of those questions. And then of course you will also know who wasn't excluded because then they will clock into work and work that day. We think that's sufficient to satisfy that record requirement. And just a note here, many counties in Michigan have also issued their own orders requiring these daily entry screenings. Businesses in those counties have to comply with both the local orders and Executive Order 91, okay? Why does that matter? Because some of those counties have additional questions that have to be asked that are not required by Executive Order 91. The most significant example is many counties require employers to ask if that person has traveled outside of the state of Michigan in the past 14 days. That will probably matter a lot, maybe come Tuesday, when we have lots of employees who travel over the holiday weekend. So make sure you know what county you're in, make sure you know whether there's an order that applies to you, and then beyond that, all businesses have to comply with Executive Order 91. All right, second question, oops. Does that health screening have to include temperature checks, right? So I mentioned that Executive Order 91 requires we ask questions of employees about whether they have tested positive or whether they have symptoms, and also whether they've had contact with somebody who is a suspected or known case. Executive Order 91 does not require all businesses with in-person operations to also do temperature checks. Okay, now let me take a step back and explain a little bit about Executive Order 91. It's got several sections that list requirements for different industries. Okay, so it's got a section that lists requirements for all businesses with in-person operations. But then after that, it lists additional requirements for certain industries, such as construction, manufacturing, research labs, office work, retail, bars and restaurants, etc. Okay. And within those, the requirements are different. Everyone take a deep breath. I know this is incredibly frustrating and, and overwhelming to try to follow. So we're going to get you through it, right? So with regard to temperature checks, that is not listed in the section that applies to all businesses with in-person operations. However, the sections for construction and research labs say that temperature checks have to be done if possible. It doesn't define what possible means, and businesses are taking that on a case-by-case basis, whether it's possible to do it or not, relying on things like, do I have thermometers available? What does my site look like, etc. The section that applies to manufacturing says it is required as soon as no-touch thermometers can be obtained. So that doesn't have the language saying if possible. That seems to be required then, unless you can demonstrate that your business could not obtain no-touch thermometers. But then there's no requirement of temperature checks for retail stores, offices, or restaurants and bars. Just another reminder, some counties have their own orders, right? So remember I mentioned those county health departments are issuing their own orders. Many of those do require temperature screening. So make sure you know what your local county is requiring as well. All right, third question. This is a big one. And I think we had a number of people ask this question in a number of different ways. And I'm certainly getting this question quite a bit from many clients. Can an employee refuse to perform in-person work based solely on discomfort or fear, right? So we're hearing a lot of that, particularly as people have maybe been off work due to a furlough or because we weren't allowed to operate. And now as Governor Whitmer is opening the economy back up and we're asking people to come back to work, many of them are saying, I don't want to, I'm concerned, I'm afraid, I don't want to get sick, okay? So when you have an employee who's refusing or declining to work, the first thing you want to do is go through your checklist to make sure they're not communicating a reason that has some sort of legal protection, okay? Here's your cheat sheet on this slide with those reasons, right? The first thing, first reason that might be legally protected is Executive Order 36. That executive order declared that employers couldn't take adverse action against any employee for being off work because they have COVID-19, because they have one of the principal symptoms of COVID-19, or because they've had close contact with somebody who's had either one. Just to note, Executive Order 36 does not apply to healthcare organizations, okay? Next on the list, make sure they're not expressing to you that they can't come back to work because they have a medical reason. So for example, many individuals are saying they can't work because they fall in one of those at-risk categories, right? I'm diabetic, I've got lung disease, I have cancer and I'm taking chemotherapy, et cetera, and my doctor says I shouldn't come back to work. Make sure it doesn't fall into an FMLA qualifying reason, whether the employee is sick or whether they say, I can't come back to work because I'm caring for a family member who's sick. Make sure it doesn't fall into one of the reasons covered by the Families First Act if you are a business with less than 500 employees. And then finally, make sure it's not covered by the Michigan Paid Medical Leave Act. Next on the list to make sure doesn't apply. We want to make sure somebody's not expressing what's called concerted and protected activity, meaning they say that they're concerned about their working conditions on behalf of themselves or others. So if an employee is simply saying, I don't want to come to work now because I don't want to leave my house due to COVID-19 being in the community, that is not concerted and protected activity. On the other hand, if an employee is saying, I don't want to come to work right now because you guys aren't requiring employees to wear masks as Executive Order 91 states you're supposed to. And I think I'm not safe, and I think my coworkers aren't safe, so that's why I'm not coming back. If you're hearing things like that, that could be concerted protected activity. Also, safety concerns and expressing concerns about violation of the executive orders, those things can fall under MIOSHA and OSHA retaliation or the Whistleblower Protection Act, okay? Now, again, if an employee is simply saying, I don't want to come back because I'm generally afraid of COVID-19, that does not fall into any of those categories and is not protected by law. What that means then is we can take action if they refuse to come to work. What many employers are doing is giving that employee a short period of time to think about their options and make a decision, whether it's 24 hours or 48 hours, right? So they're saying something like, well, we're back to work. We need you here. We'd love to have you. We've explained how everything we've done in our workplace to make it safe. We're going to give you 24 hours to think about it. And if you're still unwilling to come back to work, then you're going to have to consider either termination of employment or providing some sort of leave to that person. So that ties into our next question. How do I respond to employees who are uncomfortable returning to work, right? So when we have employees that are refusing to come back for reasons that are not protected, okay? Number one, communication is the most important aspect here. And really, this is an opportunity to lead, okay? So prior to that employee raising these concerns, hopefully we've already explained to not only them, but our workforce why it is essential for them to come back. We've spent some time crafting our recall letters so that they have the right tone, so that they assure them on safety. They explain everything we've done in our workplace, our screening protocols, our cleaning and mitigation efforts, et cetera. We've trained our employees on COVID-19 and our workplace requirements as well, which by the way is also required by Executive Order 91 now for any employer with in-person operations. We're holding town halls that include question and answers from employees, and we've done additional safety training. So hopefully we've done those things. Beyond that, if we still have somebody who will not work and they don't have a legitimate legal basis for that, the decision comes down to whether or not the organization is going to end their employment or whether they're going to provide them some sort of temporary leave. And the value, whether that employee is needed and the likely length of the leave, I would say, are the two most important factors that employers are considering in making that decision. Unfortunately, in many cases, the length of the leave is indefinite because we have people saying, I will not come back. I don't want to come back as long as COVID-19 exists. It's very difficult then to give that person a leave of absence. On the other hand, I've seen employees say, I would like not to come back until the stay-at-home order is lifted. Assuming that happens next week, that looks a little different. Just to be clear, that leave would be an unpaid leave, and likely the employer would not have an obligation to continue healthcare and other benefits during the leave. So I think I know what your next question is already. Can employees choose to remain on furlough or remain off work because they just don't want to work and collect unemployment benefits? Okay, so many of us are confronting that issue because unemployment benefits are significantly higher now than they usually are. As you all know, the CARES Act gave the state of Michigan money so that any employee who's eligible to get any unemployment benefit from Michigan now gets an additional $600 a week. Okay, and so for some employees, they make more money on unemployment than they might make if they work, or at least it's close. Okay, so in ordinary times, a refusal of available work is a voluntary quit. You don't get to refuse available work, quit, and then collect unemployment benefits. Well, of course, we're not living in ordinary times, but actually it still should be under the law, okay? We have an executive order, that's Executive Order 57, that expands our unemployment benefits for certain COVID-related reasons. But a simple preference not to work or a desire not to work because the employee doesn't feel safe going out into the community are not reasons for which individuals get unemployment benefits under Executive Order 57. Frankly, it's not even close. Okay, so what that means is it may be the case that the unemployment agency approves benefits at the front end. They seem to be approving any claim that gets filed right now because they're completely overwhelmed. And then employers' businesses are deciding what they want to do with those claims and are contesting them if they don't believe that unemployment benefits are appropriate in that circumstance. It hasn't, not enough time has passed for me to give you really good broad information about what the unemployment agency is then doing with employers who are contesting those claims. In other words, if they're then denying them or not. So bottom line, people shouldn't be getting unemployment benefits, but the unemployment agency is operating way over its head right now, and whether or not it does what it's supposed to do remains to be seen. All right, next question. If my business has reopened, can I require employees who have been teleworking to return now? So we had a couple of questions on that, and I actually have had a number of businesses call me and say, hey, we are an essential business and we've decided we are now going to open our offices, right? We want to start making all of our office employees come back to work. Well, it's important to understand that even if you are an essential business, Executive Order 91 very broadly says right now, all businesses with in-person operations must continue to promote telework to the fullest extent possible. Okay, so you have to be careful there. If we're just bringing employees back to the office for the sake of being in the office and not because they have work that needs to be done in the office versus done at home, then that probably violates Executive Order 91. In other words, if they've been teleworking successfully from home without issues and nothing has changed and there's no real need to now make them do that work in the office, I would advise against doing that right now. I'd also point out that Executive Order 91 created a new list of very significant requirements for all offices that may deter people from wanting to open their offices right now anyway. Some examples of those requirements are designated entry points for where people can come in and out. You've got to have visual indicators of appropriate spacing outside of the building. We got to do the health screenings. You got to make sure you reduce congestion for those. You got to require folks to wear face coverings in any shared spaces. You got to prohibit social gatherings and meetings. You got to suspend all not essential visitors, etc. So I would encourage you all to look at the list of things you would have to do and carefully consider then the real need to open offices and require employees who are currently teleworking to come do that work in person. Okay. All right, next question. What do I do if an employee refuses to wear a face covering? This seems to be a common issue. And it seems to have turned into a bit of even of a political issue, which is quite interesting. People are taking a stand against all of these requirements by refusing to wear face coverings. I personally am noticing that as I'm out in public too, by the way. So there is no question that all businesses with in-person operations have to provide non-medical grade face coverings to employees and have to now require them to actually use those face coverings if they can't maintain a 6-foot separation. And by the way, if you have employees that can't maintain a 3-foot separation, you're supposed to consider requiring face shields, okay? So you're supposed to require it. Executive order says you're supposed to require it if people can't maintain a 6-foot separation. If that person, though, is expressing a reason for not wanting to wear the face covering that's other than, I think it's stupid, I just don't want to, I don't like our governor, I don't like what's happening right now, and instead are saying things like, I have a medical concern with wearing it, or it's against my religious beliefs, or I fall within a protected class and I've got significant concerns about bias against me if I'm walking around with a face covering on. We're seeing a lot of concerns about that. Then there may be a legal protection there that we want to take into consideration, okay? At the end of the day, though, even if there is a legal protected reason for an employee to not want to wear a face covering, if the reality is that that person can't maintain that 6-foot separation, they still can't be in the workplace right now. So any accommodation we would make for that would probably be some sort of time off work, some sort of leave of absence, so that they don't have to be in the workplace during this time. If they don't have a legally protected reason to decline to wear that face covering, then that could be a terminable offense. In other words, your job requires you to wear it. Our governor is requiring you to wear it right now. Coming to work and refusing to wear a face covering is sort of like telling us you don't want to wear shoes at work. Okay, that's not okay. All right, if an employee has been on furlough and can't return to work once we've reopened because their kids are home from school or daycare, what do I do? Should I keep them on unemployment benefits, or should they be placed on leave under the Families First Act? This is coming up quite a bit. Okay, so to answer that question, we first want to make sure we're clear about what the difference is between those two things. Okay, so the Families First Act provides paid emergency sick leave, and then in addition to that, emergency FMLA leave for this reason. Okay, it's a total of 12 weeks. Although it might be less than that if that person has already utilized some of their FMLA entitlement for other reasons. Okay, they get legal protection, meaning they get the job protection and they get continued benefits when they are on leave under the Families First Act. They also get 2/3 of their pay during that time. Now, I want to emphasize that is a right that employees have to take time off paid with job protection under the Families First Act. On the other hand, employees can claim and be entitled to unemployment benefits for that same reason. The most recent executive order that deals with unemployment benefits is Executive Order 76, okay? Couple of things to understand. Unemployment benefits might result in more money, but they don't include a guarantee of benefits or of job protection. Also understand that currently Executive Order 76 is only in place through the state of emergency, which is May 28th. Might get extended, I don't know. whereas the Families First Act is in place through the end of the year, okay? So I believe that the better course is to utilize the benefits under the Families First Act for an organization that has less than 500 employees. That is the legal entitlement that that employee has. We're not supposed to be declining to give that to them if there's something else available. If an employee is adamant that they'd rather collect unemployment benefits than utilize their paid time under the Families First Act, I would get something in writing from them confirming that that is their choice. Understand, though, that if you let them do that, they still have all of their entitlement under the Families First Act through the end of this year, right? So if they continue on unemployment benefits through this month and maybe it gets extended through June and you allow them to do that, they can come to you on July 1st and say, okay, now I want 12 more weeks off for this reason under the Families First Act. Okay, so be careful there. All right, what medical documentation can and should I require before allowing an employee to return to work? When COVID-19 first started, the thinking by large was that we're just never going to bother any medical provider with a request for documentation because they're going to be so overwhelmed with caring for individuals with COVID-19. That thinking has changed quite a bit and has shifted more toward safety in the workplace. Okay, so even CDC is now saying employers, you should confirm with medical documentation that an employee is not likely to spread COVID-19 in your workplace if they've been off sick, okay? So our recommendation is require medical documentation before somebody can return if they've had a confirmed case of COVID-19, or even if they've been off work because they've had symptoms of COVID-19. And then, and on this slide, you can see the timing of when individuals are supposed to return after each of those. Okay, so if it's been a confirmed case, they're supposed to return after it's been 72 hours of being fever-free without medication, and at least 7 days have passed since symptoms started or they got swabbed for a positive test. Alternatively, they can return after 2 negative tests that are at least 24 hours apart. That second option hasn't been largely applied, okay? And that's the same for symptoms of COVID-19. Oops, go back a minute. Also note the EEOC supports this idea now too. Any medical inquiry needed to protect the workforce against COVID-19 is allowed according to the EEOC, and medical offices do appear much more willing to provide this information upon request. Okay, last question. Which government guidance and orders does my business, oops, there's a typo there, sorry guys, have to follow? Okay, I really like this question. We've got so much going on, as you guys know. We've got executive orders, as I said, we're 92 and counting. We've got county health department orders. We've got guidance from the CDC, the OSHA, the EEOC, etc. What do I do when these things conflict with each other? Which do I have to follow? How do I keep track of it all, etc.? Okay. Well, the orders that employers in Michigan have to comply with are the Michigan executive orders, right? So everything that Governor Whitmer is issuing, 92 and counting, those are mandated, those are required. Also, your county health department orders, okay? Those are also orders that employers are mandated to follow. One note I want to make about the executive order piece is Executive Order 91 changed that enforcement mechanism. All of the previous executive orders had said that any violation would be a misdemeanor. Okay, now I know calling something a crime is a scary prospect, right? Nobody wants to go to jail because they didn't follow safety precautions in their workplace. But from a practical standpoint, Governor Whitmer had realized that law enforcement and prosecutors had absolutely zero interest in actually enforcing those. So they really had no teeth. It was meaningless. So she changed Executive Order 91 to say that those requirements have the force and effect of agency rules and will be vigorously enforced by MIOSHA. And any failure to abide by any of them will count as a failure to provide a workplace that's free from recognized hazards. Now, MIOSHA has significant authority to issue fines, to close facilities, etc. Okay, so starting with Executive Order 91, there are real teeth there, and there are things that MIOSHA and the other Michigan agencies can do if businesses don't comply with them. Okay. On top of the state orders and the county orders, we have a number of federal guidance documents from the CDC, from OSHA. Those actually are not mandated. Those are not orders by any of those agencies, okay? So those are meant to provide guidance, but there's nothing in them that says a business can suffer penalties or consequences by failing to comply with any of those. The only slight wrinkle is that there is a tie between Executive Order 91 and the OSHA guidance, because Executive Order 91 requires employers to have a COVID plan that is consistent with the OSHA guidance. So through that requirement in Executive Order 91, one would probably argue that that means that employers are mandated to comply with that OSHA guidance. So those are the top 10 questions I have, Carrie and Susan, and I'm willing to guess that maybe we have some more follow-up questions. Is that true?
We do. We have a handful of some really good questions, so we'll go ahead and dive right in.
Okay.
In addition to Executive Order 91 and the guidelines that folks must follow, you also mentioned, Sarah, that there are county rules that folks need to follow. So the question is there a link for individuals to access to know what those county rules are and where?
Yeah, so I know Miller Johnson has a link and it's actually through, you guys can hopefully see a slide right now. We've got our Miller Johnson Resource Center, and we've got a chart of all of the county public health department orders that we're updating on a weekly basis on that. I am not aware of any other link that's available, for example, on the internet or some other place. Instead, now what any business could do is just Google search their local county health department, and most of those have their orders online, and then they would just have to read through those and look at the most recent ones.
All right. If there is an employee that lives with an adult family member who is health compromised and they have a doctor's note to continue to work from home, but this employer needs her in the office, what should they do?
That's a common one, right? It's going to depend a little bit on the facts there. So I'd need to know a little bit more. The first thing I'd need to know is whether that employer is subject to the Families First Act. Okay, so if you have less than 500 employees and is subject to that, there is a category of, there is the possibility that the employee might get 2 weeks of paid time off under the Families First Act. But then I'd also want to know whether the family member is actually sick. Is the employee home because the family member is ill and the employee is caring for that family member? Because that could fall under the FMLA, okay? But I suspect it's something else, because I'm hearing this a lot. I suspect instead it's a family member who has an underlying health condition that puts them at risk for COVID-19. and the employee might be concerned about leaving home and bringing COVID-19 back into the house because the family member lives there, okay? If that's the case, okay, beyond the possibility of the possibility of the 2 weeks off under the Families First Act, that's not a protected reason to be off, okay? So you could have that conversation with the employee about the future and what that looks like, okay? How we can't do this indefinitely. We really need somebody in your job performing this work. And so how are we going to move forward here?
Okay. This employer has a pregnant employee that has been off for now about 8 weeks, and she has no desire to come back to work until we're through COVID and she has the baby, which then she will be on FMLA. How does this employer address the time off right now?
Okay, so it sounds like that employer is willing to give some sort of leave. I'll just make that assumption, right? Some sort of unpaid leave now, and is wondering, what do I call that, right?
Right.
And if the employee, I mean, potentially it could fall under the FMLA, but I doubt it, because I don't think that employee is incapacitated from working because of the pregnancy. I think the employee is just concerned about, again, going out into the community while pregnant. And by the way, there's some dispute among infection control specialists and even within the CDC as to whether or not that's a legitimate concern. That's probably not something for us to spend time debating today, right? But that's the reality. So I think that likely is just an unpaid personal leave or unpaid non-FMLA leave. The interesting piece for me would be to try to talk more about what to do with that individual's health benefits and whether they can stay on the health plan for that entire time. It may be the case that the health plan does not allow employees to continue to remain benefit eligible once they've been off work for a period of time that doesn't fall under the FMLA. So that would be something we would need to look at as well.
What if an employee states that they will let us know when they are sick, prefers to self-monitor and feels screening is another way to use data and refuses to conduct health screening daily?
Yeah, I mean, I think right now we've got a very, very strong argument that participating in the health screening is an essential function of the job. It's mandated by our governor. Okay, so that employer absolutely has the ability to say, if you're unwilling to do this right now, this is a requirement of your job, and either consider that as a voluntary resignation or offer that person unpaid leave without benefits until that requirement is no longer in place.
Okay. What if an employee was sick and used the 80 hours of sick time under FFCRA, and now the employee received a positive COVID test and is off again for 14 days?
Right. So the 2 weeks, the 80 hours of paid time of emergency paid sick leave under the Families First Act is a total. So they don't get another 80 hours of that paid time. I do note that just bear in mind that that might fall under the FMLA though. If they're sick, if they have a positive test, I suspect that they might have a serious health condition under the FMLA. So their time off work might fall under the FMLA, but be unpaid.
Or could it possibly fall under the Michigan Paid Leave Act as well?
Yeah, good point, Susan, too. Yeah, absolutely. It could fall under the Michigan Paid Medical Leave Act if they haven't already used that 40 hours or whatever they have under that law too.
Can employees receive unemployment or underemployment if they are currently only receiving the 2/3 of their pay? Also, would they receive the $600 every week as well? Do you have suggestions on how to complete the unemployment questionnaire?
Okay. Wow. Okay. So let's take those one at a time. If they're getting paid time under the Family's First Act, they should not also receive unemployment benefits for that time. If they are underemployed, that means they're working, but they have fewer hours because we don't have enough work for them to do. They could be eligible for unemployment benefits for that reason. And if they are, they get an additional $600 for that reason. Okay. I think the final question was, do I have any suggestions as to how to complete that form? I think that's probably too broad of a question for me to effectively answer. But if there's a specific question involving a circumstance, I'd be happy to talk to that individual about that.
Okay, we have time for a couple more, it looks like.
Sure.
Do off-site employees working from home or on the road doing sales and off-site support need to go through the screening process as well, or just if they're going to be in the office?
So that's a great question. Not under the executive order. So the executive order says you have to do the screening to allow people to enter your facility. Okay, so only in that case. I have heard though of some, even though it's not required under the executive order, that business may have customers who reach out to them and ask that they do that screening for their employees because they want to know it's been done before your employee, for example, comes into the customer's workplace.
Sarah, piggybacking off that question real quick, we had a contractor who had an employee who was at a customer and went through the screening and was having some gastrointestinal issues, but unrelated to COVID. They had food poisoning the day before, but he answered yes to that question. So he was told he can't come onto that job site unless he gets a COVID-19 negative test. So is that, I mean, are doctors willing to test for something like that?
Yeah, so that's a great question, and I'll be honest. So let me explain testing a little bit. Different local health facilities are performing the tests. Okay. So for example, in Kalamazoo, the Family Health Center, in Bronson and Borges are giving tests. They have their own sort of triage screeners that are deciding who gets the test and who doesn't. There is not statewide consistency right now in terms of what rules each of those places are following. Okay. And so all I can say is, for the most part, anybody who calls one of those places and says they have the symptoms and says they are an essential worker and their employer is requiring it, for the most part is getting a test and will be tested.
Okay, good to know.
Okay, and if it's something that just needs to be done we can disagree as to whether or not that customer is being silly, right? But if it's something we just need to do, right? Because they're the customer and we want to get it done. I think it's possible. If the employee calls the first place and they won't do it, call the Family Health Center or whatever, and they will. This is also, it's a confusing area because our governor had announced that anybody who wanted a test could get it and any essential worker could get a test. There's testing for everyone. She wants to do the testing, but then the places that are giving the tests aren't really applying that. That's largely because they're being required to use their own resources to do the testing. So they don't want to give tests to everyone who calls if they don't think it's necessary. They are continuing to apply sort of a medical standard.
Well, it looks like we have 8 or 9 questions left, but due to timing, I think, Sarah, would you be willing, if we do these questions afterwards, you can just give us a little synopsis for these people after we're done. So we'll guarantee everybody's questions will be answered. But I just want to be very respectful of everybody's time, including Sarah's. So thank you so much, Sarah, for doing this for us. Just want to continue and tell everybody about our summer six-pack series, what we have coming up. Our next one is June 3rd, and it's going to be on auto reform, which we are super excited about that. Not really. So this particular one is going to be on how it impacts your business. So if you are a business client of ours or a prospect, we really encourage you to participate in that. We will do a small section on how to handle the questions from your employees from the health carrier standpoint. We're gathering all that information right now, so watch for the sign up for that one. We will be hosting it will be Tom Jager and Chad Bonner from our commercial lines team. Then we're going to have on June 17th, Pine Rest is going to be doing a leadership strategies, how we do handle this during COVID-19. On July 15th, it's going to be Gary Kushner. He's going to do the State of the Union of Benefits. We had planned on doing our survey, our benchmarking survey in conjunction with Gary, but we decided with everything that is going on, we didn't want to do our survey this year because everybody's really busy doing other things. So, but Gary's going to give us a update on benefits. Then on the 29th of July, we're going to do financial wellness during COVID-19. That's going to be hosted by Greenleaf Trust. And then in August, we're going to be doing OSHA and MyOSHA, Are You Compliant during COVID-19? So we're super excited to bring these to you. If you have any suggestions or questions ahead of time when you register, we ask that you give us that information. And I think the last thing we need to do is, Sarah, you have to pick a number between 1 and 128?
128.
130.
130.
And then we'll
All right. So I'm going to give away my age and pick number 72 because that was the year I was born.
Okay. You're just a spring chicken.
I know, right?
Hey, gosh. All right. Yep. Kim from Fiber Converters is our winner.
All
So
right.
Kim, we will get with you on your selection of what type of six-pack you would like and our cooler and some goodies in there. So thank you everybody for attending. Enjoy this beautiful, beautiful weather that we're going to have on Memorial Day. Enjoy the time with your family and stay well. Bye, everybody.
Bye. Thank you.